Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News, coming to you with some Saturday morning content for you. We've got the legal papers that show why Jane Doe ghosted her own deposition. Come on, show up to the party. She says she was annoyed, embarrassed, and oppressed by Clayton Echard. We're going to get into this court document, everything she has said right now. And also today, I've got an episode of Driving with Dave on the Dave Neal Show. You're not going to want to miss that one. You can go listen on Bachelor Rush Hour, the podcast, or over on Dave Neal Show. That'll be up at 10 a.m., I believe, Central Time. Okay, Accuser no-shows deposition. Let's get into what actually went down, what their legal reasoning is, and all that jazz. It's a motion for confidentiality and preliminary protective order. I'm going to read this and leave my comments where I see them. Not a court expert, just like you guys, very fascinated in the excuses that can go into dodging depositions, which are essentially, things you can't really dodge. But hey, there's always a case study or something you can cite. And here we are, petitioner Jane Doe, hereinafter petitioner, by and through undersigned counsel, hereby files this motion for confidentiality and preliminary protective order pursuant to Rule 53. Petitioner requests the court sign and adopt the proposed protective order as a formal order of this court, or to issue its own protective order as deemed suitable by the court. All right, so my initial layman's question is, a protective order against who? She already has one against Clayton. What's the deal? What's the deal with this? All right, so then they go over the statement of facts. On August 1st, 2023, Jane Doe filed her petition to establish paternity, legal decision-making, parenting time, and child support. On August 21st, respondent filed his response to the petition. December 28th, petitioner filed a motion to dismiss, requesting that the court dismiss the petition. Oh boy, there's a lot that happened in between there. On January 4th, respondent issued a notice of deposition summoning her to attend a deposition scheduled for January 17th. On January 11th, undersigned counsel filed his notice of appearance on behalf of petitioner. January 16th, undersigned counsel emailed legal counsel representing Clayton, asking if Clayton would agree to a preliminary protective order with relation to the deposition. All right, so all that legal talk to say they want some protection around the deposition. They're afraid that the truth is going to get into the wrong hands. Following the referenced January 16th email exchange, undersigned duly notified opposing counsel of his intent to submit this motion. It was also conveyed that petitioner Jane Doe would seek the count's issuance of a protective order prior to her deposition. So this all came in on the day before the deposition. I mean, we were vacuuming the conference room. We were squeegeeing the windows. You don't just squeegee the windows unless you have company coming over. And then they no-showed. Law and argument. Okay, so let's go over what the argument is for why they think they can get a protective order for the deposition. Rule 53 allows the court for good cause to enter in order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following: forbidding the discovery, specifying terms and conditions, including time and place for the discovery, prescribing a discovery method other than the one selected by the party seeking discovery, forbidding inquiry into certain matters, or limiting the scope of discovery. You know what's interesting? So she wants to be protected because she doesn't want annoyance, embarrassment, or oppression. I wonder if she worried about embarrassment when she took this case public. I wonder if she worried about embarrassing Clayton or even Clayton's lawyer when she accused Clayton's lawyer of jaw-dropping and false accusations. Doesn't seem like that was a big worry of hers at the time. Designating the persons who may be present while the discovery is conducted, requiring that a deposition be sealed and opened only on court order, requiring that a trade secret or other confidential research, development, or commercial information not be revealed. Well, maybe the trade secret is how you could get pregnant from a blowjob. Maybe that's, maybe there's a confidential way to, you plug your nose and wiggle your ears, who knows? Requiring that the parties by the way, I hope I'm not oppressing you or embarrassing you here. Requiring that the parties simultaneously file specified documents okay. So it goes on and on and on. The party seeking confidentiality, Jane Doe, must show why a confidentiality order should be entered or continued. The party opposing confidentiality must show why a confidentiality order should be denied in whole or in part. Well, I would say I don't work for any law office here, but the law office of Dave Neal, let's settle this one. I would say that what should be done here is, if I was on Clayton's side, I would oppose confidentiality by saying she didn't have a problem with the publicity when it favored her. We're just asking her questions and want to know what her truth is. Nobody really knows how she claims to have gotten pregnant in the first place. She's never really described that. Additionally, it requires that the court make findings of fact concerning any relevant factors, including but not limited to any parties or person's need to maintain the confidentiality of such information. Well, her need to maintain the confidentiality probably stems around her desire to not be seen as a fraudulent con person. But the more answers you get to some of these questions, the more you're pointed into the direction that somebody might not be telling the whole truth. Case law directly citing Rule 53 is sparse. However, is it as sparse as the fetal DNA? Okay, that's a funny one. Didn't mean to harass you. These are just jokes. However, as a commentary for Rule 53 states, Rule 53 is based on Rule 26. Okay, so then it goes on and on. Rule 26 provides that upon good cause shown, court may make various protective orders that justice requires to protect a party or person from annoyance, embarrassment, oppression. So I guess the judge gets to decide if asking her questions that are very specifically directed towards whether or not she's pregnant in a paternity case, I guess the judge can decide whether or not that's harassing her. I mean, look, what an audience does with that information, I can't control. I always condone it, and I know Clayton does as well. But if she, makes a stupid face and looks unbelievable, people are allowed to call that out, aren't they? I mean, that's their opinion. Don't oppress their opinion. The text of Rule 53 provides the court with no fewer than 8 separate and non-inclusive means by which it might ensure that a party is not subjected to annoyance, embarrassment, oppression, or undue burden or expense. In other words, the rule provides the court with broad discretion in fashioning orders for parties or information entitled to protection. Boy, is this boring. Are you guys as bored as I am with this? Let's get to the good stuff. Petitioners propose protective order attached hereto and incorporated by reference. Request that relevant discoverable information which either party designates as confidential remains confidential and is not disseminated to anyone other than the parties and their respective counsel, including if one party objects to the confidentiality designation and until said designation is removed by the court. The protective order also seeks that any party depositions in this matter, if deemed appropriate by the court, are designated as confidential until either party requests that the court make an evaluation into whether part. Okay, so again, this is all her way of saying she doesn't want any questions asked about previous pregnancies. Clayton's side says, we need to know about previous pregnancies because you said the same thing about those, and it's starting to feel like Jane Doe who cried wolf. Respondents' request an anticipated discovery will further annoy, embarrass, and oppress Jane Doe. Clayton's anticipated discovery is sensitive in nature and should be protected. Where protection, folks. Respondent intends to depose petitioner as is seeking discovery related to several sensitive and potentially privileged topics, including her previous sexual relations, specifics regarding the sexual encounter with respondent, previous pregnancies, discussions surrounding potential adoption or abortion, her privileged medical records, her miscarriage, and other topics. This might be the first time we hear her say her miscarriage. We don't know when she said she's no longer pregnant, we don't know what that means. But if she's claiming that this was a miscarriage, well, she has already claimed she was pregnant past the 20-week mark where you would then not be allowed to claim miscarriage. It would be stillbirth, in which case I believe there'd be fetal death certificates. So if she is going to claim miscarriage, I would think they would be able to ask her to provide proof that she did miscarry and why she would have lied under oath. Again, if that's the miscarriage with Clayton, because she says she's only had 2 abortions. She said she's had abortions before, but now if she's claiming miscarriage, why did she lie under oath Why did she say she was still pregnant when it would have never, at that point, have been a stillbirth at worst? While petitioner concedes that certain discovery may be necessary in this matter to appropriately litigate unresolved issues, including the issue of attorney's fees, this limited issue does not warrant the dissemination of sensitive information. All right, so she's still worried about attorney's fees. He's like, no, listen, Janie Dodo Bird. It ain't about the attorney's fees. Like, sure, they want to get them, but it's about proving that you were never pregnant. It's almost like she's refusing to argue the same court case that he is. Petitioner has already been annoyed, embarrassed, and oppressed by respondent's actions, and has concerns that this will only worsen as discovery continues. What are you afraid people are going to discover? The truth? Are you going to be annoyed by the truth? Respondent is consistently using his social media platforms to control the narrative of this case. All right, this is where it gets crazy. She's accusing him of using social media to control the narrative. Has anybody ever stopped this woman from getting what she wants in the past? This is insufferable. She's the one who's created multiple accounts on Reddit and responded to people and created Medium articles and went to gossip magazines. And by the way, I made a TikTok yesterday showing the email where she goes to Clayton saying she's going to go on Instagram and claim she's having the baby if he doesn't agree to date her. That's ridiculous. Is that using social media to control the narrative? At least it's threatening to do so. Respondent Clayton Echard is an American television personality, best known for his appearance on 2 seasons of The Bachelor. He's also the voice of Mr. Mucus, the Mucinex. Oh no, that's Nick File. Respondent has shoot for the stars. Respondent has approximately 360,000 social media followers across Instagram and TikTok alone. Respondent has also made appearances on multiple interviews or podcasts throughout this case, where he has discussed the situation. Oh, poor Clayton sharing his truth. Why is his truth so offensive to you? Because it doesn't line up with your lies? As a result, petitioner has been the subject of disparaging comments, harassment, annoyance, and undue scrutiny from tens of thousands of individuals online. This deliberate effort to shape public opinion has created an environment that is not only emotionally distressing. Oh my gosh, the deliberate effort to shape public opinion. This after she went to the Sun and claimed with the Scottsdale police, she was worried for her unborn baby's safety. What a deliberate effort. You know what takes a deliberate effort? Putting on a fake baby bump. That's a deliberate effort. What is going on? This deliberate effort to shape public opinion has created an environment that is not only emotionally distressing for petitioner, but also poses a potential threat to the fairness of the legal proceedings. Petitioner desires to litigate this case on the merits, free from ongoing concerns that she will receive further annoyance and embarrassment from the public. Well, she may be embarrassed. That is true. I'll give her that. She may be embarrassed. But what's stopping someone from being embarrassed when we're just sharing the truth? So here's the sub-note here. Counsel notes that specific instances of online disparaging of petitioner are not included in this motion, as counsel believes this would only encourage the conduct for the people following this case. To the extent that this court seems is appropriate or necessary, counsel will provide the court with specific instances of the public comments which are annoying and embarrassing petitioner across social media. However, any such disclosure should be protected under seal or revealed via in-camera review with only the judge and attorneys present to avoid worsening the continued impact of the case. So she's worried. So she's not worried about what Clayton's saying. She's worried about what the audience is saying. Bizarre. While petitioner Jane Doe concedes that she also made comments to organizations, these efforts were an attempt to clear up the many false narratives circulating publicly. So she concedes that she's only made comments to organizations, even though on September 18th, 2023, she shared her story with The Sun. The Sun didn't find her and say, hey, Jane Doe, are you the one that got knocked up by... No. She went to them, not only them, she went to all these other magazines. The other ones just had the wherewithal not to print the story. The court should limit the method of respondents discovering abilities. The only issue remaining in this action is the issue of sanctions or attorney's fees. Wrong. The issue is whether or not she was ever pregnant. That's the issue. It is undisputed that the parties do not share a child in common and that petitioner is not presently pregnant. Well, What is disputed is how you are no longer pregnant, and I think Clayton has the right to know. Is it because you never were pregnant or because you had a miscarriage or stillbirth, in which case, where's the evidence? A deposition is unnecessary to seek the information respondent would require to properly litigate the sole remaining issues of attorney's fees. Respondent refused to agree to enter into any preliminary protection order prior, causing necessity for filing of this motion. Given respondent's mainstream history of divulging information related to this case to the masses without issuance of a protective order, petitioner anticipates portions of and or her deposition as a whole will be discussed and or disseminated publicly, thus subjecting her to additional annoyance or embarrassment. But we just popped the popcorn. Petitioner believes discovery can be completed sufficiently through alternative means, including the use of uniform and non-uniform interrogatories, the request for production of documents, a written deposition, cross-examination, or other means. If the court does not preclude the parties from conducting depositions of the opposing parties, the court should limit the scope of the depositions to the present matter, i.e., let's only talk legal fees, not how those babies went from throat to ovary. From Throat to Ovary, a documentary. Swallow this story. The court should issue an order designated confidentially deemed discovery as protected and confidential. The present case is unique. Yeah. This court is aware of the constant struggle within Arizona courts and laws weighing the best interests of a child against a privilege designed to protect communities with certain professionals. While this case is still labeled as a family court case, the parties do not share a minor child in common, and therefore there is no obligation for petitioner to share protected or privileged information. Almost all the requested discovery to date seeks otherwise privileged information from petitioner. While petitioner concedes that disclosure of certain medical records may become necessary to support her claims, she's uncomfortable disclosing such personal and private information without a protective order in place, because she doesn't want the public to cross-examine the bullshit. Even then, petitioner should only be required to produce evidence establishing the viability of her claims instead of all medical records or HIPAA releases, as respondent has and will likely continue to request. Conclusion. For the record set forth, issuance of a protective order is necessary and can be accomplished without any material prejudice to either party. As such, Jane Doe asked this court to sign the proposed form of preliminary protective order attached hereto as Exhibit 1. Doing so will protect the parties from additional embarrassment and annoyance, while allowing this case to be decided on the merits. Well, I'm so glad she's worried about protecting the parties, her and Clayton. I know she doesn't want Clayton to be embarrassed at all by this little scenario they have going on here. This reminds me, this 7 pages here reminds me of when you have to write a 1,000-word essay and you just keep reiterating the same points in the same, thesaurus.com, Now, no offense to Corey. I mean, he shined this shit up as it's as polished as could be. So then you have the actual protective order, and then they, go over it. And, I don't think there's really too much I need to share from the protective order here. But it all comes down to not wanting to be embarrassed. Now, the question is not wanting to be embarrassed enough reason to not find the truth? If she's embarrassed by things that are the truth, then I don't think, in my humble judicial opinion, I don't think that she's entitled to not having that shared. So this is where, of course, we shared this yesterday. You can go back to last video. This is where we have a Isabel on Isabel war. Woodnick Law's Isabel versus Corey Keith Law's Isabel. A fight to the metaphorical judicial death here as they go back and forth. But Greg Woodnick responded and said, your objections at deposition are obviously limited by law. If her attempts to terminate deposition because we're asking questions that are directly related to her sanctionable actions, that is obviously your choice. I'm fairly confident that the judge is not going to agree with you, and she will be exposed to consequences, including attorney's fees and paying for the reporter costs. I have zero intention of asking questions that do not serve a legitimate purpose. Much of our time is going to be spent confirming foundation issues because your client, after she claimed she was no longer pregnant, insisted on exercising Rule 2. No matter what questions we ask, your client will claim they are meant to harass. I assure you that is not the case. And then somewhere down there, Greg says, I'm going to need you for the full 4 hours. So they basically say, clear your schedule. It's going to be a long one. And of course, here's some of the evidence that is provided by Jane Dodo Bird, and that is Clayton's Instagram. There it is. Him doing Dougie progression, online wellness coaching, and dance progression. Oh, here it is. clips of Clayton sharing his truth. How dare you go on Mr. Mucinex's show, the old snot man? How dare you go on Snot Boy Nick's show? All right, what are we going to call him? Something Nasal Nick. How dare you hang out with Nasal Nick and share your truth? And there it is, his TikTok. Again, more dancing. Could this be Clayton Echard dancing to songs that have foul language? Oh boy, get Chase J. Jones on the story here. Oh boy, Clayton's shirtless. Quit harassing my client with your shirtless photos. That's, oh boy, what are you going to do? Teach me how to Dougie. Teach me how to Dougie. All the bitches love me, but none of the bitches love me. Okay, so here it is. Paternity pending. We do not agree about the legal decision-making, parenting time. Okay, whatever the hell that means. Nobody cares. Okay, there it is, folks. We got to it. All right, I'm going to do this right now. I'm going to show you. Oh, I don't have it ready to go. I'll show you this. Here is my driving with Dave today, from broke to buying a home. My wife and I discussed moving from Los Angeles and kind of pursuing our dreams. And my hope is that it'll be a little entertaining for you guys. And maybe if you're pursuing your dreams, there's a little bit of a blueprint for you there. And in the back here, you see some of that moving paper right there. That's because we're moving into our new home today. And that's why I'm making this video early, because I'm going to be slinging boxes. And I hope that doesn't annoy or oppress anybody else. All right, very excited for all I've got going on. You can follow me on Instagram at DNeals to see the progress there. We have a ton of content coming your way. Monday is the new season of The Bachelor, and we look forward to seeing you then. Have a good weekend, everybody. I'll talk to you later.